All right, coffee topic this morning. Hopefully this video turns out okay. I'm dealing with some new equipment here. But look, I think California is on a roll here. I know the coffee topic yesterday, we talked about a California House bill. Now we're going to talk about a California workplace safety ruling. And that came out of the California Occupational Safety and Health Appeals Board. They have their own appeals board. It's a state-run plan. So what happened was a company received some citations after the compliance officers arrived at the site. They talked to a third-party contractor, not an employee. That contractor cooperated with, just started answering questions. That led to the citations. The company appealed because they didn't have an opportunity to be notified, or I guess the argument was like consent to the inspection. So what happened was the review board, appeals board, pardon me, the appeals board ruled that an employer can imply consent to a CalOSHA inspection through the actions of a third party, even if that individual lacks actual authority to grant such consent. Here's a little background. The employer, a painting service company, had impliedly consented to the inspection following a workplace safety incident when an individual who presented themselves as acting on behalf of the company agreed to produce requested documents and scheduled witness interviews. Man, so this was an incident in which an employee slipped and fell while climbing scaffolding, resulting in an injury. The fire department that responded to the incident and the employer reported the incident to CalOSHA, though reporting was not technically required because it did not result in a serious injury. So they reported it to CalOSHA and didn't need to. I mean, there you go. So all of this tells me they have a lack of knowledge of the requirements. An inspector with CalOSHA later contacted the employer and reached an individual who identified themselves as the employer's workers' comp insurance broker. Oh, this gets even better. They identified themselves as the workers' comp broker and safety consultant. This person was not an employee and at times told the inspector that an investigation was not necessary since the injury to the worker was not serious or reportable, but agreed to produce documents. However, according to the decision, the inspector was never told that the broker/consultant lacked the authority to consent to the inspection. Hey man, I thought ignorance of a fact does not exonerate you of your, absolve you of your responsibility. I thought ignorance of the law or ignorance of the standard. So I guess the compliance officer can claim ignorance of the fact, hey, they didn't tell us they didn't have authority. So basically what we're saying is there is no duty to verify on the inspector's part. So the inspector can walk up to anybody at a job site or come into a business and go, hey, do you mind if I do an inspection? And anybody that is standing there can go, okay. And it could be a customer that was coming in to shop. It could be a third-party contractor, somebody completely unrelated to the employer that they're there to inspect. They do not have to verify, hey, I need your name. Who's your supervisor? I need to verify that you, in fact, work for the company. Nothing. They can go in and do whatever they want. And that seems a little suspect to me, because I seem to recall in, let's say, criminal law that you can get a lot of things tossed out if in fact, you gained access to somebody's property, dwelling, something like that, and did not actually have permission to do so. Yeah, this is weird. And I was reading the details as I was recording. I just figured out, I'm just going to wing this one. This is crazy. So the consultant who was also the workers' comp broker, they call it broker, I think I challenge whether or not this was an actual consultant, unless the workers' comp um, management firm offers safety consulting services and was contracted to offer those services. I'm betting that they aren't so much a consultant, that they just advise them on workers' comp issues related to injuries and claims, but it's just part of the service of them being their broker. It isn't that they have, it's not like what we would do with like aero safety, right? Where we have a contract, we have a service agreement, terms and conditions, and they actually advise and consult us on occupational safety and health management issues and help us develop our safety program versus, oh yeah, we'll process this claim or we'll find you a workers' comp insurance and get you signed up and all of that. It sounds like they just really lacked fundamental understanding. They did know enough to say, you don't have to do an inspection because this wasn't a reportable, they called you, but they didn't need to. So this was a minor incident. They happen all the time. None of them get inspections. And so that's interesting. So this individual basically opened the door, and I guarantee you that painting company is no longer using them as their workers' comp broker. What do you all think of this appeals decision? Remember, the basic fact being somebody who does not work for you and has no authority to make business decisions on your behalf can trigger or allow the compliance officer to go forward and conduct an inspection that could result in citations. Not saying they did not violate areas of the standard or whatever, but look, if they were a consultant, shouldn't they have already discovered that? The consultant should be acting as the inspector. The consultant, a good consultant, when I was doing this, I had to be better than any compliance officer. I had to be more diligent than any compliance officer. I had to be more scrupulous. I had to scrutinize every aspect of my customers' safety and health management systems, documents, record keeping, training, site conditions, all of that, to put them in a better position to correct those things, right? And so it's interesting that this occurred. I'll post a link to this article. It's interesting. What do y'all think? What is your contractor risk management program looking like now, right? How are you going to brief and onboard contractors that come to the site? You can't tell them not to talk to OSHA, for example. However, you can say, you do not have, we control this property. This is our property. You do not have authority to grant permission, or you have to notify us if contacted by a compliance officer, as part of your contract or something like that. I don't know. There's some legal, gray areas there, worth discussing. I want to hear what you think. Let me know your opinion on this and how you would get in front of it legally, appropriately, professionally, and stay ahead of the couple steps ahead of this. I look forward to reading your replies.